Hello and welcome back. I'm Professor Seth C. Orenberg, and today we're discussing the topic of notification to third parties in the context of agency law. This is an important topic because it addresses what happens after an agency relationship ends, particularly when it comes to the principal's liability for the agent's continued actions. When an agent's authority is terminated, their actual authority to act on behalf of the principal is gone. But what about third parties who interacted with that agent and reasonably believe the agent still has authority? This is where the concept of notification becomes critical. To understand why notification matters, we need to remember apparent authority. Apparent authority exists when a third party reasonably believes that an agent has authority to act on behalf of a principal, and that belief must be traceable to the principal's conduct. If a principal doesn't take steps to notify third parties of the agent's termination, those third parties might continue to believe that the agent is authorized. In such cases, the principal can still be held liable for the agent's unauthorized actions. So even though the agent's actual authority has ended, apparent authority can persist until third parties are informed otherwise. The law recognizes there are different types of third parties, and the steps a principal must take to notify them depends on the relationship with the agent. For example, a third party who has previously dealt with an agent needs direct notification. This could be a letter, a phone call, or another form of clear communication, directly informing them that the agent no longer has authority. On the other hand, for third parties who may know of the agent's authority but have not dealt with them directly, constructive notice is sufficient. This might involve publishing a notice in a trade publication, updating the principal's website, or posting an announcement in a public forum. Let's think about real-world examples. Imagine a principal terminates the authority of a sales agent who regularly negotiates contracts with suppliers. For those suppliers who have previously worked with the agent, the principal needs to send direct notifications, perhaps via an email or a letter, to ensure they understand the agent no longer represents the principal. For other potential suppliers who might interact with the agent in the future, updating the company's website or issuing a public announcement might suffice. The goal is to minimize the risk of misunderstandings that could lead to liability. The Restatement Third of Agency offers guidance on the topic. It emphasizes that apparent authority persists until the principal takes reasonable steps to eliminate it. This makes sense because the law aims to protect third parties who rely in good faith on the principal's representations. If the principal's actions or inactions cause third parties to believe the agent is still authorized, it's reasonable to hold the principal accountable for that reliance. From a business perspective, principals should have clear processes in place to notify third parties when an agent's authority is terminated. This includes not only sending direct notifications to those who need them, but also updating public information like websites and directories. Failure to provide proper notice can lead to significant legal and financial risks. Imagine a scenario where a terminated agent signs unauthorized contracts with vendors who are not informed of the termination. Those vendors might have a legitimate claim against the principal, and that could result in costly disputes. To prevent these issues, principals can take proactive measures. For example, they might include termination clauses in contracts that require agents to return any documentation or materials that could mislead third parties. They might also establish internal policies that ensure immediate notification to relevant parties when an agent's authority is revoked. As we wrap up, let's review the key points. Apparent authority doesn't disappear automatically when actual authority ends. It persists until third parties are notified. Direct notification is required for those who have dealt with the agent before, while constructive notice is enough for others. Taking these steps is not just a legal obligation, but a practical necessity to avoid liability and maintain trust in business relationships. In our next episode, we'll explore the doctrines of estoppel and ratification, which address situations where principals can be bound by an agent's action, even without actual or apparent authority. Until then, consider whether there have been situations in your personal or professional life where you assumed someone had the authority to act on behalf of another. How did you come to the assumption that a person was someone's agent? And what would have changed that perception? Thanks for listening, and I'll see you next time.